We are live and on the record. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Thank you very much. Good morning. Welcome to the Appeals Court. I'm Justice Rubin. I am very fortunate to be joined today by two outstanding colleagues, Justice Kinder and Justice Desmond. We will be hearing 6 cases this morning, the first one of which is number 2912, Commonwealth versus Cunningham. The rules for argument by teleconference, which of course we're doing as a result of the ongoing pandemic, are the same as the rules in our courtroom, which is to say 15 minutes per side, and there is no rebuttal. And we will hear first from Attorney Oresti.
Thank you, Your Honor. May it please the court, Megan Oresti for defendant Sarah Cunningham. This case had a lot of issues, but I think the first one that I would like to talk about is the speedy trial issue. These are always really complicated cases because it involves going back and examining the record and the docket to find all the time periods that should be excludable or includable. But in this case, Ms. Cunningham was not brought to trial until 1,251 days from arraignment under the speedy trial rule, with 951 days when you take out the excluded time periods. And I think where the Commonwealth and I disagree, we believe, in agreement that presumptively the burden was met by the defendant to show that she did not get her trial within a year, but is the excludable time. And so I think the case at point that's relevant to this analysis is really Graham. And the Commonwealth argues that, Graham was about a case where a presumptive trial date was set, but I would say that that was just a relevant fact for that particular case. The law in Graham is really, aiming to strike a balance for both sides and looking at the speedy trial analysis, and that, that for the defense side, that you don't have to always object if you're scheduling a new event in the case in the ordinary preparation of trial, that an objection isn't needed on that, even if the judge calls it a continuance, if it's something new that they're going to be addressing.
So can I ask you a couple questions about specific, well, let me ask you a couple of broad questions first. Were all of the hearings at which, or moments at which continuances were allowed, were they in open court and recorded?
They were not. A lot of them were just notes on the docket, which, makes the analysis difficult in retrospect. However, in this case, we do have an affidavit by the defense, and we also have a motion to oppose the dismissal based on speedy trial grounds that happened at the district court level, where the Commonwealth did the calculations and conceded to certain times. And most
I'm going to ask your sister about some of those. But I'm trying to figure out how we figure out, this is aside from the Graham piece, there are some things that you say are objected to, and you have an affidavit. There's at least one where the Commonwealth said below, they agreed it was objected to, and now they're saying not objected to. They don't explain that. I'll ask your sister about it. How do we know? Well, I guess I have like a series of questions. How, and I can tell you specifically, I'm talking about the July 12 to September 27, 2018 continuance due to court congestion.
Yeah.
The Commonwealth said below, as you do, that it was objected to. Now they say not. Now maybe they're bound by their representation below. I don't know. We'll have to figure that out. But if I actually want to know if there was an objection, how would I find that out? How was this objection supposedly made? Was it made, as I say, in open court? Is there no recording of that proceeding? Have transcripts been ordered? If there is, if there isn't, why aren't there? What do I do? Do I take your affidavit as a presumption? The docket sheet is typically, in my view, typically, my brothers may disagree, crummy. It's very, very, sketchy, it doesn't have detail. So what's the answer to that question?
Yeah, all great questions. I think that I did get at the start of every case, not just this one, I go actually to the court and I go through the docket with the clerk and I ask for anything that was recorded that I can get a transcript on to be pulled. So I did do that in this case. So if I don't have a transcript for that date, which I don't see in my record appendix, then there probably wasn't one. So I had to rely on the
There was
docket.
not just that there wasn't a transcript, but that there was no recording.
I get a transcript on anything that was recorded, any hearing that was recorded. I request a transcript on, so I have that all when I first start the case, and I can hear as much as possible. And so on this case, there were several periods where I had to go back and rely on the docket and look at affidavits. But one thing that I will say is that, Graham is specific on this question that you just asked in two places. Graham says that because we have to go back and it really encourages the district court for actual rulings and when these continuances have to happen, to say that it was in the name of justice and that they weighed the evidence and that should be noted on the docket.
I agree that there is no such finding as per the rule, at least on the docket here. That's fine. But if it was acquiesced in, it was nonetheless acquiesced in. We need an objection for this to be excludable or includable, excuse me. And you say there's an objection, the Commonwealth agreed, now they're not. I'll ask your sister about that.
Yeah.
But
the Graham case.
Yeah, go ahead.
Oh, the Graham case also says that, in addition to the judge should make the finding, it's not hard to orally make that and note it on the docket, that the Commonwealth on appeal can't go back and change dates that they once said were includable, that they've waived those if under at the district court level. And in this case, they did quite a lengthy motion to oppose and then on appeal are trying to change that date that was agreed upon.
You're saying, I'm going to look at it, but it seems like an odd rule to me. You're saying that Graham says that when the Commonwealth concedes a fact, not through evidence, because they didn't put in any evidence, but in their presentation to the trial court assessing the speedy trial motion, they are bound by that. I'll find that in Graham. That seems right. What if they're wrong? Do you see what I mean? So, which is not to say that isn't the rule. Maybe they have to get it right in the trial court. That's fair enough. But are you telling me that that's really some law, some black letter law in Graham?
According to, here it is here. And this is from the Graham case. We agree that because the Commonwealth did not specifically argue for exclusions under Rule 36 when it opposed the defendant's motion to dismiss, most of these exclusions have been waived.
But they said that was excluded. But they also said it was objected to. Right? They said it was I think they said objected to, but excluded. They say a lot of things are excluded that were objected to, and I'm not sure they're right about that. But that's not quite the same as they said it was objected to, and we have to take that as a fact. Although, as I say, I can see it both ways. It might be fair to say, look, get it right. Tell the judge, we're not going to, if you told the judge X and you deserve to lose, then you deserve to lose, and that's what we're doing on appeal. You see what I mean? I could see it either way.
I see your argument on this, but I think, what the Graham court is trying to do is acknowledge that these speedy trial calculations are difficult because, dockets are incomplete and there isn't recordings of every time a preliminary status conference is held and something is either agreed to or continued to. But I think what they're saying is if this motion, this issue was dealt with at the trial court and the Commonwealth agreed that something should be included at that point when time is, it's fresher in their mind at that point. I think there's an argument to be made that it's definitely something that should be relied upon, that they've waived once they get to the appellate level, that work has been done. But, I think Graham, I've read it so many times, but I think the court really worked hard to strike a balance and say that, that defendant doesn't have to object every time. And it's difficult because judges should be noting that, things were continued in the interest of justice and these dockets aren't complete. But I think in this case, we have over 1,000 days, even when you take out excludable time and you take out the references I'm making
Yes, but
to the
it's a lot of-
affidavit, we're still over 700.
I'm sorry, Judge Desmond.
I was just going to ask kind of the same question, which is, given the kind of lengthy, complex history of the matter, what is it that you rely on for support that there was indeed an objection made? What is it? Just the memory of the lawyer, and how could they possibly remember given all of these different dates and continuances? So what is it you rely on to say that there was an objection made? Any record evidence?
Yes, there is. So it was not an affidavit done during the appellate process. It was an affidavit to the defendant's own motion when the motion to oppose went in, and it's in my record appendix, that when he opposed they were going to have a hearing on this, he did this affidavit at the time this was all happening. So this wasn't something that I went back on appeal and said, can you remember? And we created an affidavit. That is not the case here. I was relying on the record from the district court. I did have conversations to confirm it with them, but I will say, in my initial—
So it was his memory at that time?
At the time that he was preparing the motion to oppose. So during—
Nevertheless, it was just his memory. There's nothing else beyond his memory in the affidavit.
Yeah, it's not noted on the docket for certain ones, and it wasn't recorded. But I will say, I knew this particular issue could come up on appeal, and I did my calculations when I added in the ones that should be not excludable because of the Graham, because they were new events that were scheduled in the trial. And even taking out those affidavit objections that I note, we're still at 709. We're still at—
Well, I don't see that. I may have to go through these numbers again. It's a bit of a nightmare, but I don't see that. Now, in terms of the Graham piece of it, I'm interested in the period from August 27th to November 23rd, 2015. What is a motion to inspect evidence reports? And how do I know what that is? But I haven't practiced in this district court. I don't have any idea. They call things. What is a motion to inspect evidence reports?
So it's basically a discovery motion, an early stage case discovery motion in preparation for trial.
It is asking for non-mandatory discovery. Is that right?
I think it was a mix of both in this particular case. I think they were asking for records that they knew the Commonwealth had subpoenaed on the medical side, and then they were also asking for, other mandatory discovery. The motion was very long. He kind of included everything.
Do we have a copy of that motion?
I think that motion is actually in the record appendix. Let me
Good.
just double.
I'll look. I mean, your time is short, so I want to kind of keep going.
But I will say that Graham specifically did rule that a discovery motion by defendant—
I understand, but I need to understand next, what is a hearing on discovery compliance?
And is that still on the 8/27/11/23?
Yes, it's the end date. The end date was—
yes, the
hearing on discovery compliance. What is that?
So I think that's just a status hearing before trial to check in on the motions that were filed. I don't think it's a full hearing, like, a motion to
Would one have such I don't know how I'm supposed to know this, by the way, but would one have such a hearing just for mandatory discovery, just to make sure that all Brady material and so on had been turned over? Is that an ordinary part of all pretrial proceedings? Is that hearing triggered by the filing of this motion? Do you know?
This is not— I would argue that no, this is not a pretrial hearing as needed by a motion to dismiss or something that needs to be argued. This is ordinary course of trial. We have status hearings on the case throughout, getting ready for trial to see if,
then there's
things
an
are
occasion
moving forward.
record subsequently for something called, I don't remember, out of court discovery compliance date or something. Do you know the line I'm talking about in the— I can look it up, but do you know there's something called out of court? I didn't write it down, but it's something I find incomprehensible.
I did look back at this last night, and so this was not a motion that required a hearing, because
no, I understand that, but I'm just trying to figure out everything that happened, because I don't know the answer to some of these questions, and so I'm busy looking at the thing, and then it says, well, out of court deadline or something like, what does it mean out of court? Let me see if I can find I don't want to take up your time with something I can figure out myself, but I can't. Hold on. In the docket.
The docket
There's my
open.
docket.
Justice Rubin, while you're looking, can I ask another
Please,
question?
of course. Yeah.
Ms. Oresti, to the extent that we determined there was a factual dispute about whether or not something was objected to, is there anything anywhere in the record where the judge resolved disputes with factual findings? All I see are one-word denials.
There was in the record appendix, I believe there was findings on the hearing on the motion there was a hearing on the motion to dismiss on this case that the Commonwealth put in their motion to oppose, which is where I'm citing that they agreed to certain timeframes that they were not agreeing to afterwards.
So are those oral findings in the transcript?
Defendant's motion. I'm just scanning through here now. Yes, it is on page 56 of the Commonwealth's opposition. That's the Commonwealth's opposition motion. It's on page 56.
There is no record evidence. I mean, I see your time has expired, but there is no record evidence of any kind from the Commonwealth. There is just the prima facie evidence of the docket sheets. Is that right? They didn't put a lawyer in who said, no, there was no objection in terms of resolving a factual dispute.
No,
No. There's a dispute. It's the absence of a mark on the docket sheet on the one side and then the lawyer's affidavit on the other. Is that right?
Yes.
I did find, and your time is up, but I did find this. This is on April 11th, 2016 on the docket sheet. Out of court discovery compliance date ordered to wit 06/24/2016. What is that? Out of court discovery compliance date?
Most likely the court is
out of court. I don't know what the heck that is.
Most likely I would assume that that's for some type of medical record that they stipulated one party would deliver to the other, and that's the date that it's due.
Out of court? Why does it say out of court?
I think that was just maybe the defendant requested a delivery date, a date that
I
they
have
needed
no
to buy.
idea, but I'm trying to figure out to some extent. I understand that the other discovery stuff was earlier, but the other thing is also called, what's the hearing called? It's a hearing on discovery compliance. And then there's months later, there's an out of court discovery compliance date. But if you don't know, that's okay, because it's baffling to me as well.
Yeah, I mean, I spent a really long time trying to figure out these numbers and these details. But I think, even for one, and if we have an issue on one singular excluded period, and even if we take out the ones where I'm relying on the affidavit that defense counsel put in during the trial period, we're still at, well over the 365-day mark. And I knew this was going to be the bulk of my time. I do want to say though, I think within my briefs, I make very good arguments that are worth considering around the evidence of the narcotic that came in.
We do have those arguments, and if we reach them, we have your brief on all of them.
Yep, and the citation issue as well.
Yes, your time has expired. We will hear now from Ms. Nguyen.
Before we do that, can I just follow up on Judge Kinder's question? Did you say that the court made written findings to the motion to dismiss? I don't see that.
I'm going through my record appendix right now, and I actually only do see the motion that the defense put in and that the Commonwealth put in. But I can double check, and if that exists, I can make sure we get it into the record for you.
I thought it was just one-word orders or denied after hearings.
Right, I didn't see any written findings, but I understood you to say he did make written findings, and I don't see that.
You can respond to that if you have a response.
Yeah, no, I'd have to double check the record. It's the record appendix on this for that, but if I will be, be sure to note. Yep.
Ms. Nguyen.
Thank you. Good morning. May it please the court, Mary Nguyen on behalf of the Commonwealth. With respect to Justice Desmond's last question, my memory is that there were no written findings with respect to the Rule 36 motion to dismiss. And in the transcript of the hearing on that motion, the judge simply indicated that it was being denied, and there were no oral findings of oral findings. To address
to follow up on that, Ms. Nguyen, doesn't that fact in and of itself pose a problem for us if we were to conclude that there are factual disputes about whether or not continuances were objected to?
So I think that what we're left with is the fact that the case law is clear that the docket sheet and the clerk's notations that are made contemporaneously with the motion hearing are what rules. So I think that—
I thought those were prima facie evidence, and there's an affidavit from counsel that disputes those, says that they're incomplete. So do you have a citation that says we don't look at evidence, extrinsic evidence?
I don't offhand. The only citation that I have is just the rule that the docket and the clerk's logs are prima facie evidence, as Your Honor indicated, of the facts reported therein, and that's can be found in the Dorico case, which has been cited by both parties. So
in your filing below, you conceded that there was an objection on July 12th of 2018, and in fact, you described it in some detail as an objection for the record, suggesting that someone was familiar with that objection, although there's no affidavit from counsel. This is Record Appendix 57, number 27.
I do see that.
And now in your brief, you just announced there was no objection. So what's led to this change of position?
So yes, I do see on page 57 of the Record Appendix down below, the Commonwealth indicated that the defendant objected. And then in our briefing on appeal, we had indicated that there was no objection. And I think my understanding is that the Commonwealth was referring to the docket sheet, the controlling docket sheet. The docket does not indicate.
That's correct. But below, some lawyer who litigated this in the district court wrote that there was an objection, and that's what the judge ruled on. Shouldn't we accept what the judge had before him or her and say, okay, with that as the record, we conclude that there was an objection and start from there? Both sides said there was an objection on the 12th.
That's an interesting question. And I think when you were discussing whether or not there's black letter law in the Graham case with respect to whether or not the Commonwealth is wrong about a fact, I don't think that, I don't read the Graham case that way, that, if there was a factual error on the part of the Commonwealth.
But even without the Graham case, we don't let you just raise new factual arguments on appeal, do we? If the judge, for example, had ruled in Ms. Cunningham's favor based on your representation, you couldn't appeal and say, oh, we were just making that up. When you look at the docket sheet, that's nothing, right? I mean, you can't just change what facts you concede on appeal, can you?
So, I mean, I think if I'm not mistaken, I think your question is whether or not there was a waiver by the Commonwealth because of our representation below, that there was in fact an objection. Or
I don't know if it's a waiver or a concession. We say sometimes, this doesn't come up much, but we say parties can't concede questions of law, right? We say that a lot, not a lot, but we do say it sometimes because courts can't, if the parties say, well, the premise is you can get a warrant, based on reasonable suspicion, we aren't going to say like, well, the parties say that's what it is, so that's how we're going to decide the case. But if you can't, but that's for legal questions. Fact questions, parties concede all the time.
Certainly. So, and I think, I think everyone sort of raised sort of the issue in this case with respect to factual disputes and there not being findings, specific findings on the record with
You
respect to the facts.
you didn't dispute this fact below, is what I'm saying. Am I
We did
right?
not we did not dispute the fact.
And
below.
can I ask you about, also as I asked your sister,
Sure.
about this initial period, the motion to inspect evidence reports? Your
Yes,
sister seems to be right that if it's not a motion that requires a hearing, that doesn't stop the clock. The rule says delay resulting from hearings on pretrial motions. That's what Rule 36 says. And
Yeah.
I don't see a hearing on that motion to inspect evidence reports. I just see a hearing on all discovery compliance, presumably at the end of some discovery period. But I don't practice. I never practiced in that court. I don't know, there may be some special meaning or something to those phrases.
I just also wanted to add before I answer that specific question, it's on the same subject, that the Commonwealth's brief suggests that not only are we relying on that rule in the statute, but also the common law, where we cited Jericho to suggest that the defendant was responsible for the filing of that discovery motion. But putting that piece aside, to answer your question, from my reading of the record, the motion to inspect evidence report was filed and it was not acted on. But then on that same date of the filing of the motion, there was a discovery compliance and election date selected. And so I think that the inference that you can draw from the record is that that discovery compliance date was for the purpose of the Commonwealth to comply with, to the extent it could, without there being a ruling yet on the motions to inspect evidence.
I don't understand that. The judge didn't hold a hearing or order compliance with that. There has always got to be a discovery compliance date because there's Brady and so on, right?
So this is difficult because I think it's outside the record because we don't have any further information than what's beyond the docket sheet. But just in my experience, way back when practicing in the district courts, if to the extent we could resolve discovery issues, including discovery motions, there would be a discovery compliance date, and then the Commonwealth would provide, what it could in compliance. And then also
your burden to show, isn't it? It's your burden to show in a case like this where we're well over the year. It's your burden to show what is excludable, and I can't tell that this hearing date had anything to do with a pretrial motion filed by I'm not saying it didn't or it did. I do hear what you're saying. I can imagine all kinds of delay. We go, oh, I didn't know you'd need to find whatever it is, an evidence. What is it they asked for? I didn't know there'd be a motion to inspect evidence reports. Give them a year. They're going to have to get the evidence reports, although I don't know what evidence reports are, and I'm guessing it doesn't take a year to find them. But right, some of the delay or all of it could be attributable to this or not. How do we figure it out?
It is a difficult question because, as you had also suggested, there's that out of discovery compliance date as well on April 11, 2000.
You don't know what that is, right?
So that just in my experience, and this is outside the record as well, there are often times where the judge will or the parties will agree on an out of court discovery compliance date, so the parties don't have to come in and they can resolve discovery issues, amongst themselves. So my interpretation.
Why is it called that? I mean, isn't a discovery compliance date always an out of court date? Everyone have everything to each other by January 30th or whatever. You don't have to come back into court, do you? On that day?
In many instances, it can be an out of court discovery compliance date, but in my experience, I've had numerous in-court discovery compliance and election dates. But I acknowledge it's difficult to answer that question because we are bound by the record and we don't have that information on the record. And then also there's some language that I just wanted to raise in Graham about, it incumbent on the defendant to file motions for sanctions or Rule 14 motions with respect to discovery. So Your Honor had brought up that question, whether we're dealing with that motion dealt with mandatory or non-mandatory discovery. So I just wanted to raise that point too. But there was another issue raised during my sister's argument about.
Before you move on, was there any objection to the motion for to inspect the evidence reports?
From the Commonwealth?
Right, well, you didn't bring the motion, so yeah, from the Commonwealth.
Yes, I did not see any notation with respect to an objection from the Commonwealth. So just my reliance on
Let
the
me
record.
also ask you this, just the fact that the actual discovery compliance date is until the following April, doesn't that suggest that no delay was engendered by the filing of this motion?
Well, the first discovery compliance date was scheduled for November 23rd, 2015, which would have been the next date.
Hearing, it says, right? Hearing on discovery compliance.
Correct. And then that date ended up being continued and there was no objection by the defendant. So
Okay, but I'm talking about the period that ends on that date. I'm talking about from the filing of the motion. So in a way, the question always in these cases is, what's just the normal course of pretrial proceedings? It's not supposed to take more than a year, right? And what are things that are caused by or acquiesced in or of benefit to the defendant? And so I'm trying to figure out whether this period of time, this November, whatever it is, August to November period, is just the normal process of, hey, everybody come on in November. We'll see if discovery's been complied with and we'll have a conference about that. Or if it's a case where the defendant says, I want evidence reports. And the court says like, geez, I was gonna end discovery compliance next week, but if you want these reports, let's push it off till November. Do you see what I mean? I need to figure out, I think, which it is. Or put another way, I think it's the Commonwealth's burden to prove it's the second one.
So with respect to that, that's why I'd raised earlier that the Commonwealth is not only relying on that statutory exemption, but also on the common law. And that's, and I don't have anything further to add beyond that. And I did want to, if I could, move on to sort of the conversation we've been having about the Graham case and sort of the distinction between scheduled cases versus delays like continuances. I think Graham is still very clear, and it also cites a case where the defendant is obligated to object to delays. That part has not changed. There's just a distinction between scheduled cases, scheduled for the first time versus actual delays. So with respect to the objections, I did want to raise the case, the Borden case, which is 71 Mass Appellate Court 420, a 2008 case. And it again just reiterates that the obligation is on defense counsel to object to delay, and that the defendant cannot sit by passively, but must make sure that an objection to a specific continuance is timely noted. And with respect to, there's some language in Borden citing to other cases that to avoid ambiguities that often ensue, like this case, for example, such objections should be noted in the contemporaneous docket or minutes of the session clerk or filed in the form of a written objection. I would suggest that that the affidavit, which was not contemporaneous with the proceeding, but was filed months later as part of a Rule 36 motion to dismiss, is not a contemporaneous record that should be prima facie evidence of the facts in this case. And the defendant was required.
We know these district court dockets. I appreciate what you're saying. We know that they are inadequate, right? I mean, not everything that happens in these things winds up on that docket, does it?
So
I don't understand why there isn't. Now, may go well beyond this night. You have a tiny amount of time. Why isn't there a recorder going in the courtroom all the time? I don't understand. If something's on the record, put it on the record. Is that not the practice that people go in and they argue before a judge and it's not being recorded? Is that typical?
It's been a while for me.
Yeah. All right. I mean, I don't know either. I just don't understand how you can run a railroad this way.
Well, I apologize.
This was at the time of FTR, right? This is the automated recording. I just want to be clear. No?
That I'm not sure of.
All right.
And my sister's nodding no.
Yeah, yeah.
Or, so that I'm not sure of, Justice Desmond, but I did want to just expand. So Borden also talked about the obligation to object, clearly on the record, but also another alternative would be to file a written objection, presumably contemporaneous with the event, and that didn't happen in this case. So I think that when we rely on what we know is prima facie evidence of the facts, that being the docket sheet and the minutes of the clerk, and the minutes of the clerk actually, if you look at the record appendix, they're handwritten notes, and if you look at July 10th, 2017, and I can give you that page number, it actually notes that there was no objection, although counsel in his affidavit is indicating there was an objection. But here we have.
Oh, that's just one example, but your time has expired. We did give your sister a little extra time. So I also want to make sure that the judges, these cases, and we really appreciate the assistance both of you have given us. These cases are a morass. What's the start date? What's the end date? How do you count them? In the middle of it, something happened. It's incredibly complicated. So we really do appreciate the assistance you guys give us. But if other judge has a question.
I just have one follow-up on your point,
Sure.
and that is, given the morass and the absence of any findings, why wouldn't it be reasonable for us to remand this case for the judge to make factual findings regarding what time is excludable and what time isn't?
That's certainly an option to the extent that this court does not think the record is adequate with respect to certain factual disputes, but I defer to this court in that regard.
All right.
We are live and on the record.
Good morning. Our session this morning continues with number 20-112, Commonwealth versus Sin. Welcome, counsel, to the appeals court. I'm Justice Rubin, and I am joined today, as you are, by my two excellent colleagues, Justices Kinder and Desmond. The rules for argument by teleconference, which we are engaged in, of course, due to the ongoing pandemic, are the same as those in our courtroom. Each side gets 15 minutes and there is no rebuttal. And we will hear first from Ms. LaRoche.
Good morning, members of the panel. Sarah LaRoche for Ricky Sin. May it please the court. Trial counsel provided ineffective assistance of counsel to Mr. Sin at trial by failing to pursue not one meritorious defense, but two: the third-party culprit defense as well as the alibi defense. This was a case that really rose and fell with the credibility of Vinara Ram, and to a lesser extent, his girlfriend, Vinara Pan. This is not an overwhelming case for the Commonwealth, so the credibility of Ram was incredibly important. Trial counsel had at her disposal, as part of these two defenses, the alibi defense and the third-party culprit defense, which were intertwined and supported each other, she had at her disposal significant evidence to show the jury that Vinara Ram was not a credible witness, that Vinara Pan was not a credible witness. In addition, she had evidence available to her which showed that Vinara Ram and Chem Pan were present at the scene at the time of the shooting.
Was there any evidence of animus between Ram and Sang?
No, there was no evidence of animus between either Ram and Sang, Chem Pan and Sang, or Mr. Sin and Sang. There was no evidence whatsoever on that point. So trial counsel had at her disposal evidence to show that Ram and Chem Pan were present, that they exhibited consciousness of guilt after the fact, and that Mr. Sin was somewhere else at the time of the shooting. Yet, inexplicably, she did not introduce or corral the evidence that was available to her.
Didn't she put that before the jury?
She put certain things before the jury. Yet, and just sort of starting and focusing on the third-party culprit defense, she had a misconception that she needed more. That she needed more in order to, as she said, I can't point the finger at either, she focused on Chempan. She said, I can't point the finger, I don't have that. But there was no additional magical evidence which trial counsel needed. The evidence that came in at trial and the other evidence which she could have moved to put in was sufficient to raise a third-party culprit defense.
But didn't she argue essentially a third-party culprit? I mean, she didn't name somebody, but didn't she put in all the evidence as to it could have been the other two guys who were running away and they were on the wrong side of the victim, and Ricky Sin was in other places, and there's evidence that suggests that. So without naming a third party, didn't she put in all the things that you?
Well, one thing I want to correct right off the bat, she did not say that Ricky Sin was elsewhere. She put no evidence in that Ricky Sin was elsewhere. She said it in opening statement, but she didn't put in any evidence that he was elsewhere at the time of the shooting. None. And as far as the evidence that
I read her closing to be only, it was dark, Rom couldn't see well enough. There's your reasonable doubt. I did not hear in that or read in that closing a third-party culprit argument at all.
No, I agree with you, Your Honor. I mean, she makes reference to the fact that a witness saw someone running away who looks like Chempan. She makes reference to that, but she does not say there were third-party culprits here. And I think she didn't do that because she was under the misperception that she couldn't. And the evidence in Finney, Alcide, and Conkey, these are cases that had similar kinds of third-party culprit evidence, and counsel affirmatively, unequivocally said, there are other people here who could have done it, and it wasn't the defendant. But I also want to zero in on just a couple of points that counsel, I think she misunderstood what she needed to put the defense in, but she also failed to marshal what she had. And I want to make a couple of points just about Faria's testimony. So Faria is the disinterested bystander who sees the events. He drives down this narrow one-way street. He turns around. So he's in the driver's side. He's a short distance from the group in front of 13 Gold Street. It is true that the number of people he says before the shooting that are gathered is different from what Vanara Ram would have us believe. But more important, and I failed to really raise this and crystallize this in my brief, more important is the fact that Faria, he hears the shot. He's then looking over at what's happening. He does not see anyone go into 13 Gold Street. Both Vanara Ram and Vanara Pan would have the jury believe that Ram went in immediately after the shot, met up with her, and that the two of them then went down and exited the building and returned to Bosang. So there are two pieces of important evidence there that Ram and Pan really differ with Faria on. That is, Ram does not go in, and only, Faria tells us, Vanara Pan comes out. He is out of his car. He's across the street. He is standing there with Bosang, and he says a woman comes out of 13 Gold Street, presumably Vanara Pan, not Ram. He does not say that Ram is there. He says he converses with Vanara Pan. He does not see Vanara Ram. The jury should have been alerted to this major discrepancy between disinterested Faria and highly interested Rom and Pan. This was a moment for the jury to understand that Pan and Rom's testimony was not credible. And in a
When you say highly interested because they happen to be there?
they happen to be there and then they act guilty after the fact. They
Because
don't,
they flee from the shooting.
yeah, their friend is shot, they run away. Vanara Ram, they don't call 911. Chem Pan, he hightails it away from the shooting. And then the police characterize his efforts as efforts to interfere with the investigation. And Chem Pan, he's yelling things like, "Don't snitch." So we have guilty behavior after the fact, consciousness of guilt on the part of these three people. And we also have on the part of Rom and Pan, this story that they create about Mr. Sin is at the scene between 9 and 10, and he's skulking around. He's looking for Chem Pan. That's what Vanara Pan says. He's looking for Chem Pan. Vanara Ram tells us he's not with his kid. His kid is not with him. He's not doing innocent dad stuff. He's skulking around. He's looking for Chem Pan. Chem Pan is upset when he hears this information. That's what Vanara Pan tells us. But this is all a fiction. This is a story that could have been easily corrected with the testimony of Jocelyn Coppola and perhaps her mother, Tammy Coppola. Mr. Sin was driving his 2-year-old around. He's got a 2-year-old in the back seat.
Well, you don't have to prove that, right? Your
No.
point is the jury should have been able to know both things, and they could decide the facts. He might well still have been convicted. They might not have believed that story, and they might have believed this story or whatever, but it wasn't presented to them.
It was not presented to them that both Pan and Rom were not credible witnesses, at least as to certain things that they testified to, in a case where their credibility was crucial, and that they acted guilty after the fact, and that Mr. Sin was someplace else.
Ms. LaRoche, what do we do with the judge's observation in her written findings that placed great emphasis on Rom as a percipient witness and concluded, based on the strength of his testimony, that the claims about the third-party culprits were speculative? Don't we defer to her in this context?
Her findings are erroneous, and you do not need to defer to her when her findings are erroneous. She, the third-party culprit evidence, when you look at other cases like Finney and Conkey and Alcide, you see similar evidence of people present, of consciousness of guilt after the fact, statements made, what would have been hearsay statements admitted in Alcide, where a person makes an admission. This is not speculative evidence. This is evidence which has consistent evidence has been admitted in other cases. And in those cases, it was found to be legitimate, powerful third-party culprit evidence.
Doesn't Judge Brigger cite Finney when she says that she's not going to give the limited instruction on third-party culprit, but says she will allow her to argue the evidence and to suggest that it was a third-party culprit?
Well, yes, but as Justice Rubin pointed out, she really doesn't go there in her closing argument. She missed the boat. She missed the boat by failing to understand the evidence. I think those discrepancies between Faria and Rom and Pan, Faria on the one hand and Rom and Pan on the other, are really important. I think she failed to understand what she had. And then she failed to corral it and really, marshal that evidence and zealously argue that there were other people that could have done this.
Was the recording of Faria's 911 call in evidence?
It was.
Do we have it?
I did not have it provided to you, Your Honor, but I would be happy to do so.
This is where either he is asked to describe the shooter. Is that how he describes the word shooter is used by the dispatcher or by Mr. Faria himself on the call?
Your Honor, I have to apologize. I don't remember whether my memory is that he uses the word shooter. But, I can't.
And then describe someone everyone seems to agree is Mr. Pan.
Yes. It's a person in a long sleeve shirt, very.
No, I get it. And there is police testimony without elaboration that says, we concluded it was Mr. Pan. He was describing not the shooter without any further testimony about why he's not also the shooter. But okay, that's all there is in there as far as I can tell about this.
Yes.
Okay.
And just the one point that I wanted to make on the alibi defense with respect to trial counsel's, first of all, it was an unequivocal promise. The first words out of her mouth to the jury are, Sang got shot and Ricky Sin didn't do it because he was somewhere else. Those are the first sentences she says to the jury. Memorable stuff. And then the only other point I want to make.
You're saying that's the alibi? Is that the alibi she promised?
Yeah, she promised. She said, Ricky Sin was there and then he left. He went to be with some friends on Fernald Street and Bo Sang got shot. And it wasn't Ricky Sin. That's all she said.
And you say that constitutes a promise of an alibi defense?
I do. And in her affidavit, she tells us the only thing she was concerned about was that the witnesses that she called could have been impeached with grand jury testimony. And I want to be clear that Narat Chan is one witness who could have testified about an alibi, who did not testify to the grand jury, and therefore her concern about impeachment by grand jury testimony is not relevant with.
But the way, am I correct that the way he knew that Sin was at the house was Jenny told him? And isn't her testimony before the grand jury not even equivocal, but at the end she's like, certainly by 10 minutes of 11. I mean, I'm not saying that's impeachment by his grand jury testimony, but it's not right. I mean, it could be undermined on cross-examination.
I suppose, but when I read his affidavit, Your Honor, I read his affidavit to mean yes, my girlfriend told me a time when he arrived, but I was awake and with him for 3 hours.
Okay. Your time has expired.
Thank you.
Thank you for the argument. We'll hear now from the Commonwealth. You're muted, yes.
Good morning. May it please the court, Hallie White Spate, Assistant District Attorney for Middlesex on behalf of the Commonwealth. The motion judge, who also provided a trial, properly exercised her discretion in concluding that whatever other evidence that was not before the jury might have been introduced, it was not sufficiently compelling, either taken separately or together, to warrant a new trial. The vast majority of the evidence that the defendant proposes as alibi, as third-party culprit, as Bowden evidence, it was all before the jury. The only thing that wasn't there was the testimony by the 3 roommates at 6 Fernald Street. Their grand jury testimony is actually highly inculpatory, suggesting that he went to Fernald Street after the shooting. Narat Chan only says, my girlfriend woke me up at 10. He doesn't say, I looked at the clock, it was 10 and I saw Ricky Sin standing there. It's very much at odds with Jenny Seng's testimony before the grand jury. it's simply not compelling enough to warrant the allowance of a new trial. And in fact, it could have been, as the Commonwealth argued in its opposition to the motion for new trial, it could have been highly damaging, because if the jury believed that he only got there at 11:45 that night, he's with his buddies playing Black Ops and Call of Duty right after shooting Bo Seng in cold blood. There was ample reason not to offer this. And it's clear from the record, by the way, there was not a dramatic promise in the opening. She says he was not there. He was with his friends. There's no, you're going to hear testimony from 3 roommates at 6 Fernald Street that they saw him and that he was with them. There's nothing like that. And it's clear from the record that even up to the point the Commonwealth rested, she was wrestling with the question of whether to call these witnesses.
Commonwealth offer any motive for the shooting?
There was never any evidence of motive for any of the, either the defendant or Champan or Venera Ram. There's no evidence of motive for any of them.
Was Bo Seng the actual host of the get-together?
My memory of the testimony is that it was Bo Seng and his girlfriend who hosted the get-together. Whether it began in their apartment and wound up out on the stoop in front of the building, I don't think is totally clear from the evidence, but yeah, he was the host.
But he wasn't allowed back into the apartment by his girlfriend.
There was some argument that erupted and she locked him out, and this is why.
We know nothing about that. We don't know if it had any bearing, nothing to do with Ram or with Pam.
There's absolutely no, I'm sorry, there's no evidence of what the argument was about. The girlfriend didn't testify, as I recall. Venera Pan didn't know what it was about. She went upstairs to knock on the door and see if the girlfriend, whose name is Serena, I think was her name, would let him back in. And that's when she heard the shot. She's coming downstairs. She sees Ram running up the stairs saying, "Call 911." So there's no dramatic promise of alibi. And the alibi witnesses, had they been called, any or all of them would have given weak, equivocal testimony at best, and at worst open to serious impeachment with their grand jury testimony. As for the third party culprit, the defense counsel, trial counsel, says in her affidavit, "I did the best I could with the evidence."
Yes, but she says, we're trying to find out if what she did was manifestly unreasonable, right?
Right.
And she says, I believe that I was told I couldn't do it, but she was never told that.
Well, the judge in the charge conference,
the record,
when they're discussing, I'm sorry, go ahead.
No, please. You're
in the charge conference, and I normally have these things tabbed in my transcript, and I don't have it right in front of me.
I've read
but they're discussing instructions and the parameters of closing. And what she says, I think that the question is about limiting instructions for a third-party culprit and where she can go in closing. And she says, "I don't believe I have enough to point a finger directly at Ram."
She doesn't say that. She says she's not going to. She doesn't explain why. Oh, she does say something like,
she says,
I don't think I have it, or something. Okay, why doesn't she have it? What, right? So this is not a funny case, but interesting to me, because we always use this phrase, substantial ground of defense. And usually we're not even talking about a literal ground of defense. We're talking about, an argument about something or other, or a motion that might have been whatever. An eyewitness said Pan was the shooter and said there are only 3 people there, not 4. How can you not argue that? And all she's got instead is it was dark, so you shouldn't believe this guy Ram, who's an eyewitness. I mean, her whole closing is, don't believe Ram, it's not beyond a reasonable doubt. How could a competent lawyer not argue was one disinterested witness here. He said 3, not 4. I understand there might be arguments on the other side. I get that, of course. I'm not saying I'm not saying he gets acquitted. I'm just saying, how could you not argue? And when asked, whatever he says now, and he wasn't, neither side, I guess, wanted to get anywhere near, did you see the shooter and who is it? Nobody asks him that, Faria, on the stand. No, on direct and on cross, nobody says, did you describe this guy as the shooter? So I don't know what's up with that, but I assume no one knew what the answer would be, so it was too dangerous for both sides. But in any event, on this recording, either asked to describe the shooter or using the word shooter, he clearly describes Pan. How could you not? What? I mean, that's a defense. That's a substantial ground of defense, like by definition, isn't it?
And that evidence
I
that
didn't ask about that evidence. Yes, there are scattered throughout the record. There are all these things. Of course, the police officer then says, oh, no, he wasn't describing the shooter. He was describing Pan. Like that's an answer. But yeah, it's scattered throughout. But a lawyer doesn't just put a bunch of evidence on and walk away. They have to marshal that evidence and say, look, I mean, or they did not make that defense. She did not make that defense.
I'm trying to recall if there was anything in her closing about the description of short, skinny kid running up the alley.
Not as the shooter.
Doesn't she say on trial day 5, page 46, that if Mr. Brown is asking me if I'm going to stand here and say Mr. Pan shot Mr. Sang, no, I'm not going to do that. I'm
a bad lawyer.
I am going to attempt to argue inferences, as the court has indicated, that someone was seen running up the street, and that was the testimony, statement of Mr. Fair that was in the 911 call. And yes, I am going to attempt to do that. I'm not going to point a finger specifically at one person. I don't have that. So
and she did argue that.
Why doesn't she have that? Why is she calling Pan the shooter on the 911 call? I mean, right, I'm not saying Pan was the shooter. I'm not saying Faria could even see the shooting or saw it. I'm not saying that at all. All I'm saying is you're a defense attorney, you're trying to defend your client, and you have a disinterested witness putting less people at the scene than need to be there. Admittedly, as I say, I think there's arguments both ways about why he might have done that, but he did. And when asked to describe the shooter, he describes Pan. That, to me, that's I mean, I guess I'm just repeating myself. I don't mean to argue with you, but I don't understand why that's not a substantial ground of defense. I don't understand. I see what Judge Desmond read, that I know that she said that. I can't figure out why. I can't say that it was Pan. Why not? Isn't that the single best defense? Go ahead, I'm sorry. And I don't know that I don't mean to say she's a bad lawyer. I don't know anything about this lawyer. I don't even know who.
Well, I think you just did, Your Honor, but go on.
All right. Well, I am saying if it's ineffective assistance, then that's fine. Ineffective assistance means below what you'd expect of an ordinary fallible lawyer. So yes, I am saying I can't say it's Pan when the evidence would support that inference, in my view, seems obviously my brothers and I haven't deliberated about this yet, and they may disagree with me, but I don't see how you can fail to make that defense and say that you did the job a lawyer should do, effective assistance of counsel. So instead of bad, let me say ineffective. I don't get it. I don't see how you cannot raise that defense.
Does the defendant suggest that Ram could have been the shooter, or that Ms. Pan could have been the shooter?
Nobody has suggested that Ms. Pan is the shooter. There seems to be some implication on the motion for new trial and on appeal that it might have been Ram. The focus, as I recall, seemed to be more on Champagne at trial. And the evidence of the description fitting Champagne somehow in connection with the word shooter. And I have not actually heard the tape. Ms. LaRoche doesn't recall what's on the tape. And this panel has not heard the tape. So I think before we leap to conclusions about what it says, somebody should ask that for that tape to be transmitted and actually hear it, if that's what all of this is going to turn on. The jury heard the tape. They heard it. It was clearly before them whatever he said and whatever connection between short, skinny guy, long sleeved shirt and shooter was made. The jury heard that. And to say that counsel is constitutionally ineffective, sufficiently ineffective to require a new trial simply because she didn't say in her closing, Champan is the shooter.
She didn't say anyone else. She didn't have to name, I mean, she could have named him. She didn't say there's a third party shooter. She said Rom couldn't see because it was dark. I mean, I understand some of what
she says the Commonwealth hasn't met its burden to show beyond a reasonable doubt that Ricky Sin is the shooter, and that amounts to the same thing, because if it wasn't Ricky Sin, it was someone else.
Well, yeah, but
and I don't think there are sufficient connecting links, substantial connecting links, to support anything further. The idea that there was consciousness of guilt, it's consciousness of guilt only if you assume they're guilty.
The Commonwealth's position is that running after the Commonwealth's position now is that running after someone's been shot is not consciousness of guilt. You need other evidence to show they're guilty.
Yes.
That's the Commonwealth's position.
Yes.
They all I look forward to hearing it in future cases. I haven't heard that from the Commonwealth.
Without some other evidence, it would not be, you would not get a consciousness of guilt instruction on that. And she didn't ask for one.
Being from the scene of a shooting?
When someone's been shot, you run. And I believe this court has said similar things.
I just haven't heard that from the Commonwealth before, but I agree with you.
I think by itself, it doesn't establish guilt, and it doesn't establish.
Well, it doesn't. It is routinely. Well, it's for the jury to decide. I think it is routinely.
Yes, absolutely.
It is routinely put in as evidence.
Flight to avoid prosecution is routinely admitted as consciousness of guilt evidence. And I think what we are missing here is
to support seizures of people after shootings, to support seizures of people all the time. The Commonwealth puts this in, and that it's a high crime area.
Often very skeptical of that.
Say again.
I say this court has often been very skeptical of that argument.
I don't know. Mixed bag.
I mean, I don't. This is not, and to the extent that it is.
We are live and on the record.
Good morning. I think it's still morning. Welcome to the appeals court. I am Judge Rubin. I'm joined by Judges Kinder and Desmond. And the next case we will hear is number 20-980, Gardner versus DANGELO. The rules for argument during teleconference oral argument, which is what we are holding today due to the ongoing pandemic, are the same as in our courtroom. That is 15 minutes per side, and there is no rebuttal. And we will hear first from the appellant, Attorney Kobe.
Good morning, Your Honors. James Kobe for defendant appellant Robert DeAngelo. As you know, the issue on appeal in this case is what is the appropriate statute of limitations to apply to count one of the plaintiff's complaint, which was entitled Resulting Trust, Declaratory Judgment Resulting Trust. Now, Mr. DeAngelo contends that the applicable statute of limitations for resulting trust claim is 6 years, as stated by the SJC in the case of Stapleton v. Mackey. In that case, which involved a claim and interest in land, the court plainly stated the applicable statute of limitations for purposes of enforcing a resulting trust is 6 years. And the court cited to General Law, Chapter 260, Section 2, and to the case of Hanrahan v. Hanrahan, which is 342 Mass 559. Now, Plaintiff Gardner contends that Hanrahan is inconsistent with Stapleton, and his brief at page 20 states, in the Hanrahan opinion relied upon by the Stapleton court, the court refused to bar a claim for resulting trust after the 6-year statutory period. I read the case differently. The headnotes to the case contain the following summary. The statute of limitations, General Law, Chapter 260, Section 2, was not a bar to a suit in equity to enforce a resulting trust in corporate stock commenced within 6 years after repudiation of the trust by the defendant trust, although more than 6 years after the creation of the trust.
I believe it was first year of law school that they told me the headnotes aren't part of the opinion.
They're not, but they are consistent with the opinion, Your Honor, and they provide a useful summary, I believe.
Well, maybe some lawyer at West's in St. Paul has come up with those headnotes.
Well, I'm going on to the opinion.
I
itself.
haven't met those lawyers, although in law school I was also told something about them, but I'm sure they're fine people. I'll keep that to myself.
I would just say the headnote is consistent with the opinion of the court, which states that the statute of limitations for a resultant trust does not run until repudiation.
Lufkin says it starts with repudiation of the trust.
Correct. And in that case,
There is a letter from your client to the father's lawyer and maybe to the brother, but the plaintiff here is the sister.
Well,
And I don't see any open and unequivocal repudiation of if there is a resulting trust. And I'll ask you about that in a minute. Assuming there's some trust here, and that the letter was even supposed to be a repudiation of it, all of which seems highly contestable to me. If it wasn't sent to her, then the statute hasn't run, right?
Well, the motion judge already found that the breach of contract claim was barred, was dismissible because brought more than 6 years after the breach. I think that the time periods run the same, and the repudiation.
Lufkin says repudiation. Lufkin says open repudiation of the constructive trust.
The letter.
So it starts at a different date, and that letter, even if the letter's repudiation, how do you get around that it didn't go to the plaintiff?
Because the
Or her lawyer?
plaintiff had knowledge of the letter as found by the motion judge. The motion judge said that letter repudiated her contract claim, which I think is essentially the same thing. It said this deed was an invalid deed. He repudiated the deed itself.
Well, whatever that means, repudiated the deed is I signed a contract. I don't know what it means to repudiate an already effective legal document, but let's are you saying that there is a fact finding that she had knowledge of that letter? Am I really going to find that?
I believe that's part of the motion judge's opinion.
I'll take a look. I don't want to waste your time because I have a more fundamental.
I didn't see it in Judge Davis's opinion, but you tell us that Robert, when he executed the deed, was not represented by counsel. Why point that out?
Well, I'm just trying to point out that this was a person who, I know the trial judge has already found that he understood the deed that he signed, but his position was he didn't at the time. He tried to undo it immediately. He was rebuffed. When the deed was finally, an attempt was made to record it, he then retained counsel.
I'm going to ask you a very complicated, well, if that answers Judge Desmond's question.
It does.
I'm going to ask you a very complicated question. What does this case have to do with resulting trusts?
Well, I believe that the judge found.
I agree with that, but what does that mean? How could this be a resulting trust? I understand how a deed could be effective and the title owner could be the siblings. That I understand, but I don't see anything alleged or found here that has anything to do. When did he hold it in trust? Who had an equitable interest and why? I don't understand that at all.
Again, the complaint, the count in issue is entitled DJ.
Yes, but we know that the complaint itself doesn't have to properly state a legal theory, a short,
Right.
simple statement of facts. Blah,
Well,
blah,
let
blah.
me shift to the scheme in issue, which I think was prompted by Medicaid considerations.
Maybe it was fraud, but that also isn't.
No, but I'm
exactly
trying to
right.
respond to your question, Your Honor, as to the.
Okay, all right.
He gets a letter saying, come to this meeting. There's no letter explaining what he's supposed to do. He's presented with a piece of paper. He signs it. Then his brother signs another piece of paper. And then he sort of figures out what happens later. But clearly what was going on was that he was given a deed to deed the property from himself to himself and his siblings. And thereafter, his brother signed a separate deed as guardian of the father, transferring the property from the father to Robert as caretaker child, because this was the only way the property could be kept from Medicaid if it went to the caretaker child. So, I mean, I have questions about the efficacy of that when they transfer it to him after he's already transferred it out, and it happens immediately. But the resulting trust argument, I believe, is because the plan was then to hold that deed from Robert to his siblings in escrow until the father died, which didn't
Well, what
happen.
does that sentence mean, in escrow? I understand it wasn't recorded.
Well,
My understanding, I don't know if there are findings of fact about this or if it's disputed or not, that the idea was, well, maybe between now and when dad dies, we'll reach some other agreement. So let's not record it.
well, no, I think well, again, I wasn't there, I wasn't part of it, but I assume the understanding was hold it till dad dies, because if we record it before he dies, then Medicare will say,
Okay,
property's
so
not
we're
held by
busy committing fraud or whatever, which is not the issue before us.
Right, but
So our lawyer will help us commit
I
the
think
fraud
that-
by holding this deed in escrow. But be that as it may, the judge found, and this seems like it has to be right, if it's a good deed, not a good deed like doing a good deed, if it's an effective deed, this deed, it's effective when it's signed.
well,
And so he isn't the title owner. And I thought only a title owner can have a resulting trust, because the title is in one person, legal title, and then there's an equitable owner who is the, whatever you want to call them, the beneficiary of the resulting trust. But if this deed was effective when signed, he wasn't the title owner. He was there by agreement with the other two title owners. And this isn't a resulting trust case, whatever the judge said or however it was pled. I don't see a resulting trust. I don't see how there can be one. Do you disagree with my understanding of resulting trust law?
well, I was responding to the decision of the judge.
I agree, but I don't understand. I mean, the part of the judge's decision I understand is it was her deed. It was not hers alone. It was the three siblings' property the day that deed was signed. That I understand. I'm not saying it's right or wrong, whatever, but that I get. But then if that's the case, then this isn't, whatever it is, it's not a resulting trust case. I know then the judge goes on to declare it, I guess, because he was asked. But the resulting trust does nothing because, or saying it doesn't mean anything. He was the title owner for an instant or never, right? I mean, and so he can't have a resulting trust.
Well, let me switch to a different argument, because again, on the resulting trust, I'm responding to the way it was pled and the way it was ruled by the judge. And I think under that theory, the statute of limitations is 6 years under the cases of Stapleton and Hanrahan, and Nantucket is not to the contrary. But the other major argument is that the motion judge raised on his own the issue of Beaconsfield's 20-year statute of limitations for the recovery of land applying to this case. And I contend that that is a misapplication of Beaconsfield to this case. I mean, in reading Judge O'Connor's dissent, there's a real question about whether the 20-year statute of limitations should even apply in Beaconsfield. But Beaconsfield at least did have a sense that there was a prior ownership of property established by the condominium trust, and that a lease of parking spaces out of that trust thereafter was invalid because the condominium statute says you can't divide common areas in that way. So it was, in some sense, a claim for recovery of land that was established by some pre-existing right. This case is very different. This is a case meant to establish in the first instance Ms. Gardner's right to that property, as opposed to a case to recover a pre-existing right. And, you know, the Judge O'Connor also noted that the statute of limitations of 20 years before had only been applied basically in prescription adverse possession cases. And there was a subsequent decision by the SJC, which also held the same thing. It was White v. Hartigan, that this statute governs actions to prevent the establishment of prescriptive rights. That is not what's going on here. We have a complicated scheme with multiple moving parts over many years. And CHERYL Gardner, you know, is seeking to establish as part of that scheme, she's basically seeking to enforce that scheme in this case. And that is essentially a contract action. It's much similar to the schemes in Stapleton and Hanrahan than it is to Beaconsfield, where plaintiffs had a independently established right to land that then was lost by a subsequent action. Again, her count one seeks to establish her right to land. She says there's a dispute. We want you to declare who owns the land. So it's sort of circular to say, because I won the case, I had the land before, and therefore I can use that to establish a 20-year statute of limitations. I think if you look at the gist of the action, which you do under a declaratory judgment action, the gist of the action is to say, I was promised that certain actions would be taken by my brother, namely that once my father died, he'd permit us to record this deed, and he didn't do it. And for that case, it should be a 6-year statute of limitations.
Recording the deed is wholly irrelevant, seems to me. At least to our, I mean, it's obviously not irrelevant to a million things, but it's irrelevant to this. So I'm just looking now at the motion to dismiss order. And it says, plaintiff's complaint includes counts seeking a declaratory judgment that she is the, quote, rightful owner of a 1/3 interest in the property as a tenant in common, unquote, and that defendant holds her interest in a, quote, resulting trust, unquote. And as I said before, if we knock out the resulting trust part, why is this a contract action rather than an action to say I'm the record title or one of the record title holders of this real property?
I think there's still a distinction between an action to establish someone's title and an action to recover a previously established title. I mean, all the adverse possession cases, someone has title to property and then someone moves in and encroaches on that. And then they have 20 years, because they have a previously established title, a long time, to push back on that encroachment.
What if they just have a title? You say previously established, usually there's no earlier court case. They just hold a deed.
Well, they hold a deed.
And then they're like, this guy is on my land, please get off.
Right, but there's no dispute about the validity or enforceability of the deed that has to be resolved in those cases. Those cases aren't about the prior deed. They're about the subsequent.
Well, you have to show that you're the title owner, or you can't kick somebody off.
Right, but I think there is distinction. The reason that 20 years exists is to protect prior title holders whose title is not at issue, not to allow someone to bring a new dispute about a title.
Okay, we understand your argument. I think this is an incredibly interesting and complicated case, and your argument has been very helpful to us. We will now hear from Attorney La Rochelle.
Thank you, Your Honor. May it please the court, I think, Justice Rubin, I think you've hit on exactly the points that I want to make. And the essence of this appeal is, what is really the essence of the claim down below? And I have to confess, and I will later, that I'm the one who introduced the term resulting trust in this case. And having thought about it now for a couple of years, I don't think it's a resulting trust case, and I'll explain that. What this case is about is in June of 2000, defendant D'Angelo voluntarily and knowingly signed a deed conveying 1/3 of the interest in the property at 14 Wheelock Circle in Franklin to my client, CHERYL Gardner. Those facts have been found by the court below. They're not in dispute. They're not on appeal.
The judge declared that the property, I guess, was being held in a resulting trust.
He did not claim it was a resulting trust, Your Honor. He did find in his judgment that it was being held in trust.
What does that mean? I don't understand that.
Well, I think that's a natural outflow of a finding that one person was in possession of property that that another person actually owned as an equitable and in this case, an actual at law.
No, when someone is occupying a piece of land that someone else owns, they're called a tenant or a licensee maybe, or an invitee or a trespasser, right? I mean, they're not called a trustee.
In this case, though, Your Honor, and again, I think Your Honor's hit the point on the head earlier, so I'm happy to engage with the court about trusts if you want to talk about trust, but I think this case is actually about ownership and possession. In this case,
So should we ignore paragraph 8 of the judge's order? First, by the way, paragraph 7 is all about resulting trust, so I assume when he finds him to be trustee in the next paragraph, it's resulting trustee. After all, that is what you pled and probably argued. Defendant Robert D'Angelo is declared to be trustee for plaintiff CHERYL Gardner, holding a 1/3 interest as tenant common in the property at 14 Wheelock Circle, in trust for her from the date of June 5, 2000. What date is that? The date of the signing of the deed?
That is the date of the signing of the deed. Yes, Your Honor.
I don't understand how he can hold it in trust. It's hers and his.
Wait. It is hers, but it is also, I mean, until this case began, Ms. Gardner did not ask Mr. D'Angelo to leave the property. He was there as an invitee. By our view, he was there as an invitee. By his view, he was there because he thought he owned the entire property. And so it's certainly appropriate for the court to impose trusts, and does so, resulting trusts and constructive trusts, especially when a person who is not actually in ownership of a piece of property has had possession of that property, because it would be unfair otherwise for Ms. Gardner.
But whether it's a resulting trust or some other kind of trust may matter, because your brother says, and there's a lot of old case law, Lufkin and the like, they are about real property, and the court is going, but it's an action for a resulting trust, and from the day of repudiation, you've got 6 years, you cannot rest on your equitable right, we're not going to let you. I don't fully understand where that comes from, since I would have thought it's latches for an equitable right, not statute of limitations. They all say statute of limitations, but I still don't fully understand. Are you saying there is a resulting trust here, or you're not?
I'm saying that there's a trust here. I don't think it's necessarily a resulting trust.
You
But
think
the trust doesn't exist.
not a resulting trust?
The trust doesn't exist until the court imposes it in this case. This is not a case where there was a contract that established a trust. This is not a case where there was a declaration of trust that established a trust. The trust only exists when the court imposes it. Now, the court does impose it retroactively. That's true. That's a common equitable result that courts do when one party has possessed a piece of property, or one party has possessed a piece of property that another one properly owns in the past. But Mr. D'Angelo, in this case, did not repudiate the trust in 2009. The trust didn't exist in 2009. What he did in 2009 was he said, Ms. Gardner doesn't own this land. It had nothing to do with the trust. He repudiated her ownership. And the repudiation of her
Does a
ownership-
tenant hold property in trust for its owner?
I'm actually not sure as I sit here, Your Honor. My instinct is to say that a tenant does hold that property in trust, because if the tenant destroys that property, whether or not there's anything in the lease that allows the landlord to recover for the destruction of property, certainly equitably, the landlord would be allowed to recover for the destruction of the property. And therefore, to that extent, and that's the extent we're looking at here, that property is held in trust by the possessor for the benefit of the real legal owner.
Such a funny way to use the word trust, but all right.
And later in, if I was going to go through the speech that I had planned to talk about, I was going to fall on my sword and apologize for ever bringing the word resulting trust into this case, because I think it was done improvidently. But what the court should look at today is that this claim at its essence, as you've indicated, Justice Rubin, is a claim for recovery of the property that was once in 2000 clearly belonged to CHERYL Gardner. And in 2009, Mr. DANGELO said, hey, this is not your property. Attorney Kobe says this is very different than a classic
Adverse possession.
thank you, adverse possession claim. But it really isn't, because the classic adverse possession claim is person A owns the property, and then person B comes on and says, it's now mine. But that's exactly.
But I take it she was looking for a declaration of her right. She wasn't insisting on kicking out the tenant, invitee, guest, whatever he is.
Not as part of this case. Now, because I don't think we can do that in this case. We've already planned after this appeal is over.
You could partition or whatever.
That's what we're going to do. We'll petition to partition later so that she can actually liquidate her interest.
Yeah.
And that's basically what I wanted to say, Your Honor. I know Attorney Kobe points to the Stapleton case, and the Stapleton case does say, I can't deny it, the applicable statute of limitations for purpose of enforcing a resulting trust is 6 years. He's absolutely correct that it does say that. I don't think anymore, despite my pleading, my inartful pleading, this is not a resulting trust case, but it is a case where Mr. Gardner or Mr. DANGELO, because he lived on the property and possessed property that was not entirely his, is held to be a trustee for CHERYL Gardner for that 1/3 for whatever he does with it while he's there. If he destroys it or diminishes its value in some way, certainly he is answerable to her for that. And that's what the trust that Judge Kirpani imposed on him effectively does.
All right. Well, further questions? I see none. It is a darn interesting case. We have our share today, though. So thank you both very much. Very helpful arguments, because I find this a very interesting and complicated area. So your arguments have been very helpful to us. Thank you. So I don't know if I'm not supposed to use names or what, so I'll just say each one is captioned in the matter of child with 2 different children involved. And I don't know what the impoundment order is, but I would caution the attorneys not to use the names of the children if that's what the impoundment order covers. You would know better than I, and whatever else is impounded obviously shouldn't be referred to. Because these are really the same case, the parties, with the parties' consent, will be hearing a single argument in the matter. The rules for argument, when we do argument by video conference, which we are doing today in light of the ongoing pandemic, are the same as they are in our courtroom, which means we do 15 minutes per side and there is no rebuttal. And with that, we will hear first from Attorney Mello.
Good morning. What we have here is whether or not it's in the best interest of these children, these twins, to change their last name. They have their mother's surname. It is her birth name, which is why it is a privately protected last name. So when I speak today, I'm just going to, if I need to refer to it, say it's the last name of C. So should their name actually be changed now, their last name, now that they're nearly 5 years old, to the father's last name? That's why we're here today. Would it be in the best interest of the child? No one disputes that it's the best interest of the child standard that's applied here. Father requested the name change, and so he bears the burden of bringing forth evidence showing that it is in the best interest of these children to change their last name from that of their mom to his. Yes.
Can you point to the judge's findings where he suggests that it's in the best interest and why to change the name? Point to the finding that explains to me why it's in the best interest of the child to have the name changed.
Yes. He states, we're in the record appendix 25 would be where the decision is. There's basically two identical. And he said that each of the categories for the 4 factors, and he's picked up the 4 factors that have been taken out of the Richards and the Jones cases, that he finds that in each category listed above, and he puts in quote, the children's relationship, length of time with his current name, age, and any difficulties or embarrassment, the court finds it to be in the furtherance of the child's best interest to allow for the name change of the child's last name to that of the father Gomes.
But why does it do it?
I take it Justice Desmond is asking you the opposite question, which is that it's fine and good why there's no harm, particularly from changing it, but that's not the standard. The standard is it has to be affirmatively in the child's best interest. So, because there's no presumption anymore. So I take it he's asking whether there are any findings that actually support that.
I would say that no, they are not. And in fact, the facts that he sets forth in the findings, which is on the 2nd page of his decision, none of these actually support that a name change is needed here. He gives facts that maybe they speak to what a factor is. For instance, the one having to do with age. So, we have the age of the child as it relates to identification with the surname. So, for instance, there, he states that they've used the name for a relatively brief period of time, the age of 3 at the time of the hearing.
So why is it in their best interest to change it?
It doesn't do that. And in fact, we have 2 other cases. In Jones, I believe the child there was only 7 months old when the petition for name change was brought, and that was not supported on appeal. And in fact, in Cormia, I believe the child was 3 at the time. It does not in and of itself support for a name change, and neither do any of these other facts that are found here. Cormia says, we ought to look at who the custodian is, should be a factor. Mom's the custodian. The judge here says, child has resided full-time with the mother since his birth. The parties share legal custody. The father's endeavored to develop meaningful relationship with child, including financial support and active presence. But both parents have active presence. Both parents support. And our cases in Jones, this court cautioned about using the fact that a parent looking for a name change to his is trying to get that and be more favored because they've paid financial support or lived up to their parental obligations. Everything being even here with both of these parents, that factor does not play for a name change. We have also another factor. Let's see. The age of the child's the identification with the surname, the length of time the child has utilized it. Again, at the time, the children were about 3.5 when this came to be discussed at a pretrial. This was not actually a per se bench trial, but the mother offered, and the judge says in his decision, mother offered, child entered daycare, regularly attends medical appointments with his current name. Child eventually knows his current surname. Court finds the child has not entered any formal schooling that may establish a public identification with his surname. But again, here, we're kind of backhandedly saying the children do recognize their last name. It's being used. But again, this doesn't support, we need to change the name to Dad's.
Mother was pro se?
Mother was pro se, yes. And in fact,
Has this been
yes.
stayed pending appeal?
I'm sorry?
Has this been stayed pending appeal?
No, it hasn't been stayed. I don't think the parents have done anything to effectively change this. I do think that the parents have, do try not to, they do work together well. That's also in the transcript for the pretrial conference, is that these parents work well together. A name change is not needed here because Dad has a poor relationship with the children, or he needs the name change to further his bond with them. The record on pretrial is replete with both sides saying what a great relationship that he has with the kids.
This is the name that they've had on their birth certificate.
Correct. And in fact, father recognized his paternity at the hospital with mom, because they were also together at the time, and signed all of the record, giving the kids mom's birth name, her surname, from birth at the hospital.
I saw something in the papers that father was an only child and has no other children. Does that bear at all on the best interest of the children?
Your Honor, it doesn't. We're supposed to be looking at this from the best interest of the children, of what they need. Everything is supposed to be equal, saying, mom doesn't want it to be changed. Father does not want it to be changed. So to say, well, he is an only child, that's why he wants it, or he doesn't have any children with his own name, that's his desire. That is not a desire of the child. That is not something that necessarily plays on whether it's in their best interest to change it. It may be in father's interest to change it, but not in the children.
Ms. Mello, this proceeding seems somewhat abbreviated in that evidence was taken by the judge from one of the parties only. In the normal course in the probate and family court, would there be a full evidentiary hearing or trial?
It usually depends. Usually the parties are asked to put in a pretrial memo. I did not see a pretrial memo put into this record. I was obviously, my client was pro se at the time. There is no pretrial memo on the record for either of these parties here. Usually if either party is not intending to call any witnesses to support their position, or a judge is free to actually treat it as a trial when it comes before him or her for pretrial conference. This is also not something that this judge actually mentioned or highlighted at the beginning of this pretrial conference. He actually started the pretrial conference by advising in part my client that he'd already read what she submitted and saw her objection, asking her if she had anything additional to add to that, and then asking her some questions. Much of the introduction or the overview or facts of this case were given by representation of the legal counsel that represented father. So he did much.
Do you agree that the procedure that was adopted by the judge was agreed upon by the parties at the hearing?
At the end, he asked them by saying he did not think that he needed to hear anything else or from any other witnesses to make a decision here, and that he could certainly consider whatever he'd heard that day would end up being something he would decide on, and if they were agreeable to that, and both sides said that they did agree to that.
So does that mean we should treat the representations of counsel for the father and the evidence put in by the mother as undisputed facts? Are there no disputed facts?
I think there are very little disputed facts, and even the ones that are disputed may not necessarily weigh in on whether or not this is the best interest of the child. For instance, we don't rely for keeping mom's surname for these children on the fact of whether or not the mother and dad were in agreement before the kids were born, which is something that came up as to they would have the mother's surname. So that fact is been disputed, and that's disputed in the record. But aside from that, that would not carry this case. That would not show best interests of these children to change their name one way or another.
No, but are we supposed to treat this as though you both agreed, do this by summary judgment, Judge? I mean, I just don't know. I thought the way this was done was really poor. And I don't know why the judge suggested it, and the father didn't even put in any evidence. I don't know, what's a representation of counsel? It's nothing. Yeah. So, I mean,
but they do continue even in their brief to make the same exact representations. That is how they chose to do it. He did have legal counsel.
But you agree, you agree it's no problem for us if we conclude that any disputed facts are immaterial, that we can rely on both the representations made by father's counsel and the actual evidence in the record? Is
yes,
that okay?
I believe so. I don't believe that these parties really dispute the underlying facts or the facts of this family or the situation. But I think if you look at all of this, there are not facts here that say that these children need to have their last name changed to that of the father. Even the facts in the decision that the judge put in there, even adding in the other disputed facts that came out from the pretrial conference. None of these facts, looking at the objection from mom, anything on this record, this family circumstance doesn't require a change. These children are not embarrassed by their name. They're having no difficulty with their present last name. Nobody argues that they're going to. Everybody argues that, everybody agrees, that there's a great relationship. Dad has a great relationship. What we have here is dad wants the kids to have his last name. They don't need to have his last name. Right now, they're in a household. They share the last name with mom. They also share it with an older sibling. Sure, they have two other siblings who don't, and those two siblings took their dad's last name when mom was married to them. So right now, there's two different last names in their family household. Okay, if we're going to even look at it as there's another name in the household, if we follow down the road and say, well, change it to dad's last name, then there's three last names in the household. I still don't see even how that bears on, it would be better for these children to have a change in name. None of these facts actually support that. Most of these facts are very neutral. There's no need to change these children's names. They're doing very well. This family has good bonds.
Okay, I think we understand your argument. I mean, you do still have another minute if you want to add something or if there are questions.
I would just add that I think that, we agree on the standard. I think that most of these facts are not argued. One side tries to spin them maybe a different way. And I don't think that that's a good spin, but even trying to spin them, these children don't need a change in name for their well-being or to be well adjusted in society. They're doing well. And I think this judge looked at the standards and the facts, but he didn't actually apply them, and he didn't find it really is in the best interests. And I don't think that we can let this stand. I think it needs to be reversed.
I think we understand your argument. Thank you very much. We
Thank
will hear
you.
now from Attorney Young. You're muted, Attorney Young. Still muted.
Okay, can you hear me now?
Yes, indeed.
Thank you. Thank you, Your Honor. Karen Young on behalf of Father, co-counsel in this appeal. Attorney Fernandez is viewing this hearing via the live stream. Your Honor, in this case, the lower court judge did properly conclude, based on the totality of facts presented, that changing the twins' name to that of father did serve their best interest, and the judge's findings demonstrate this determination. And by the way, the decision, my sister mentioned something about changing the children's name at 5, but this decision, first of all, the filing took place when the children were 2. Father filed the petition it was heard when the children were 3. And
Maybe you can answer Judge Desmond's question to Attorney Mello. There's a lot of reasons in this opinion why it wouldn't be that harmful to change their names, but what's the affirmative reason for it? I didn't see a reason given either by counsel in his representations in open court or in the opinion. Why don't you have the burden to show a reason for it?
so I think, Your Honor, the judge in his findings demonstrated the reasoning. He did look to all of those variables that my sister cited. And by the way, may I just interject, this judge at the very inception of the findings indicated, look, I'm not attributing greater weight to the interests of either parent.
Yeah, but then he
And
acted as if the presumption was change it. He went through all the factors and said, yeah, this will be fine. They're still young enough, blah, 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 as if there was a reason for doing it. What's the reason?
Your Honor, I think the family constellation. I think he looked at
What does that mean?
The siblings, the relationship with the siblings.
What about them?
Siblings share the name that the child has right now. One of them does.
Well, the child's
Children, I mean.
Mother's 20-year-old daughter used her father's surname until she reached 14 or 15. Then mother sought to change the surname to
Okay, but in this case, there was an agreement by the father and mother to use the mother's surname, and they did so for 2 years. Why change it?
First of all, Your Honor, father disputes that.
Did he sign the birth certificate?
Under the condition they were in, he indicated, he explained that. He said, look, we were in the hospital. I wasn't going to make a big fuss. But
so he didn't make a fuss. Instead, he signed the birth certificate. Maybe that's when he should have made a fuss. Then for 2 years while they lived together, he didn't come into court.
They actually
broke up. So he allowed the name to, at least allowed the name to be used for 2 years, right?
The couple separated about a year after the birth, it indicated. But
Did
yes,
he
the
allow
children
the
were
name?
2.
Okay. Now, what's the reason for changing it now?
The fact that the children closest in age, one of the facts, that not a single fact, but the judge indicated that he relied heavily on the fact that the other 2 children closest in age to these twins used their father's name.
So how is that in the best interest of these children to change it? That's what I don't understand. 2 things. One is, for the year that they lived together, he didn't want his own last name to be their name, right? The year that they lived together in the same household, he didn't move for a name change to his surname.
Your Honor, while that's true, he didn't take any action until they were 2.
Okay.
There was no, he said he wanted it all along.
So that being true, then the other children, what difference does it make if these children have their name changed with relation to the other children's last name? I don't understand that reasoning.
Your Honor, in Jones and Richards, it did make a big deal. The facts in the Jones case, the members of the child's household, the mother and half sister both used the mother's name, and the court ruled that changing that child's surname could result in potential embarrassment. And likewise,
I'm sorry, I don't understand. Right now, the child has a different last name than these 2 intermediate age, the twins have a different last name. It's the mother's than these 2 middle children. They'll also have a different last name from these 2 middle children if they have their fathers. So where's the embarrassment?
With respect, Your Honor, the court determined that they should have that the court issued a decree changing their name from mothers to fathers. So at this point,
right? Just tell me why it's in their best interest. In a way I can understand. Why is it in the kid's best interest?
I think there are a number of factors, and it all goes back, Your Honor, to the standard, the standard enunciated in Jones and Richards, the formula for making the decision as to the best interest. And that was, as noted by my sister as well in her brief, articulated by Richards and Jones. And the first factor is the preservation and development of the child's relationship with each parent and other siblings.
Okay. So why is it in the best interest to preserve that relationship? Why is it in the best interest to change the name?
Well, I think all of these cases are very fact specific. And if you look at all of the facts surrounding this case, and based on what the judge had to go on. And by the way, the parties agreed to this. Mother was certainly entitled to have an attorney represent her in at the hearing, at the pretrial.
Are the kids having some kind of hard time with their current name? Is that why?
I'm sorry, you mean presently, Your Honor? I'm
I
not
mean,
aware.
at the time of whatever it wasn't a trial. At the time of this conference, when these arguments were presented to the judge, were the children having some difficulty?
There were no facts.
Did
to
you
suggest that.
anticipate them having some difficulty?
Well,
And was
Your
that
Honor,
presented to the judge? Because I didn't see that.
no, that's correct, Your Honor.
All
Thank
right,
you.
so they're having no difficulty, and you don't anticipate any difficulty.
Well, I think
So why would a change be warranted?
because of all the variables inherent here, Your Honor. Clearly, custody was a big issue that Mother raised in her brief. And to suggest that there should be a presumption with a parent with custody would be as bad to go back to the
How about
historical.
I'm just talking about these aren't unnamed children. This dispute didn't arise at birth. These children have names that they've been called. I know they're only 2, but we've all seen 2-year-olds. They know their first and last name generally. Okay. So the question is, and it's your burden, why change it? I can understand if you said to me, we went in the day these kids were born, they have no name, which one should it be? Well, I don't know the answer to that. And I might say, well, custody can't exactly be it, and this can't, and that, okay. But why change it? They already have a name. And nothing you've said tells me why it ought to be, why the status quo, if it's your burden to change it, it seems equally good to have either parent's name, and they happen to have their mother's because he agreed to it. So why change it? I think that's all I'm asking, and maybe I don't want to speak for Judge Desmond, but.
Again, Your Honor, with respect, the evidence indicated he didn't agree to it. He didn't want to cause an issue at the hospital, but best interest is a moving target. And he did it when they turned 2. He went into court and requested the name change. And I would argue that the best interests of these children involve a number of variables. It involves their relationship with their siblings. Why do their siblings have their father's name, but not these children? If in fact you follow that reasoning, that why not just keep their mother's surname? Why do the children closest in their age have a different? And frankly, the record did show that.
And is your concern about that something about illegitimacy or something?
Your Honor,
She
I'm
was
just
married to the father of the other one and gave them her name. I think she was not married to the father here. Is that right? They were together, but
That's
not
correct.
married.
That's correct.
I mean,
Your
I
Honor.
don't know why she chose this in the first place. So they're going to think they're illegitimate because they have their mom's name. Is that what you're saying? Or I don't get this. I'm not sure that's legitimate.
Again, Your Honor, I'm not saying that specifically. What I'm saying is that this involves, and as the standard points back to, the children's relationship with family, with siblings. The record showed that the children were aware there was a dispute. Paternal grandmother, who was very close to the children, who cared for them, as the record indicated.
Doesn't the judge say there was inadequate testimony to indicate significant difficulties or embarrassment that may occur for the child as a result of the proposed name change?
I think that he does say that, Your Honor. That's one factor. But again, I'm claiming that there's more evidence to consider, and there are other factors that are cogent that should be considered. And it all relates. It's not about the parents, and that's the key thing. It's about the best interests of these children, and the best interests of these children involves their relationship with mom, their relationship with dad, the relationship with their siblings, extended family.
Ms. Mello cites the Cormier case in support of her argument that one of the factors that should be considered is the allocation of custody. And it seemed to me, based on this record, that factor would favor the mother's position, but the judge didn't seem to at least make any findings regarding that. Do you disagree?
Well, with all due respect, Your Honor, that was his first finding when he first the Lord, he recognized in his decree, he recognized that the primacy of the children's interest, indicating that their best interest must be considered first and foremost, and then went on to note that the children resided with mother. But again, custody shouldn't be a presumption in these cases, as my sister argued that she cited a California case, Schiffman, for the contention that custody should, that the parental custody should prevail in these matters. So the court didn't ignore that. The court acknowledged that. Again, it was the very first subsidiary fact that the trial judge found in this case. And if we consider the Schiffman case, if custody in and of itself should be the primary and singular consideration in naming a child, that's no more fair than years back when the court favored a paternal name assignment. I mean, if you consider all these factors, dad's no longer living with him. Mother stated that these children had a very good relationship with him. And she even contrasted it to the relationship that her older children had with their father. She said, I don't want that for them. They have a good relationship. The judge, there was some evidence, mother said, well, we wouldn't be here, but it wasn't clear as to what that meant. Wasn't clear.
Oh, I know what she said. I don't know if that's a disputed fact. I thought it was pretty clear that she testified that he had said to her, if we were still together, I wouldn't be doing this.
But we can only speculate what that means. Does it mean that since he no longer resided with the children, he felt that his bond with them was weakened by his lack of daily contact with them? And look, mother has them every day. She has the capacity to engage with them every day.
Or maybe that's what he meant. Maybe that's what he meant.
We don't really know, Your Honor. So I'm just arguing that these cases are not so simplistic, that other factors, other jurisdictions have recognized a plethora of other factors. Paternal misconduct or neglect, for example, a child's preference. Clearly, these 3-year-old children at the time that the court decided this case weren't really mature enough to offer a preference. But there are a number of variables that the court consider. And I would just argue that the judge's decision in this.
But here, the mother, there's no allegation that mom's not keeping a clean house, that mom's not getting the proper medical care, that mom's not getting the kids in daycare or attending school, that mom's not allowing dad to visit and share time, that there's some dispute with respect to the parenting styles. There's none of that here, right? You agree with that?
That's correct, Your Honor. But I'm not suggesting that that should be the basis of the name change. Maybe that's a variable and other,
So what's the basis of the name change?
The basis.
What are you suggesting is the basis of the name change?
The entire facts that granted, this was not a detailed evidentiary, we don't have a lot of facts to deal with, but based on the facts that we have, I'm arguing it is in the children's best interest based on the relationships with their siblings, based on the constellation. There were 2 or 3 different names in the house.
The only thing that you've come up with, it seems to me, as a fact, is that the 2 middle children use their father's last name. That's the only thing that you've mentioned in terms of constellations or whatever. That's a fact at all. Just using words like constellation doesn't get us anywhere unless you tell us what the facts are. And that's the only one that I've heard. And I don't know how how a court is supposed to take that into account exactly.
Well, again, Your Honor, I'm arguing that it's the totality of the evidence in the record that, and the judge properly concluded that it was in their best interest to change their surname to that of dad.
All right, I think we, at least to some extent, understand your argument. We have your brief and your brief as well, Attorney Mello. Difficult and unfortunate case, I think, but there we are.